Dear participants to tonight's webinar, welcome. My name is Pascal Pichonnat, and as president of the European Law Institute, it is my privilege and my great pleasure to welcome you all to this webinar entitled Data Act, How to Boost the European Data Economy. As always, with our regular webinars around various topics, I will not present the ELI, but limit myself to draw your attention to our website, on which you will discover all our projects, activities, news, and where you could also apply to become a member. So www.europeanlawinstitute.eu. The idea of this webinar came up when the Commission published on 23rd February 2022 its proposed regulation on harmonized rules on fair access to and use of data, a regulation which is also known as the Data Act. These new measures complement the so-called data governance regulation proposed by the EU Commission in November 2020 as the first step of the European strategy for data. While the data governance regulation creates the processes and structures to facilitate data, the Data Act clarifies who can create value from data and under which conditions, and of course, a lot around these data and data rights. The European Law Institute, the ELI, supported from an early stage the Commission's work, among other aspects, through its ELI principles for a data economy, and later by submitting a response to the European Commission's public consultation on the Data Act. The ELI has therefore a keen interest in this evolution, and we thought, therefore, that it might be useful, interesting, and certainly also beneficial to discuss the Data Act and its potential to boost the European data economy during a webinar which should take place now. Of course, we will only be able to tackle a number of selected issues. But I do not want to enter myself into more details, given that we have tonight a wonderful panel of reporters, both of the project, ELI project, drafters of the response, but also experts in the field and people from the EU Commission. So they will each have 10 minutes to present a first aspect, and then we will have about 30 minutes together to speak, to discuss your questions and give some answers or potential paths for further reflections. Let me already thank the panelists for giving us the pleasure of being with us today. I'm truly looking forward to their presentations, I must say, and their reflections, which might certainly nourish us all in the field of data economy. But before listening to them, let me just stress that you will be able to ask questions by using the Q&A function to put your questions, and you better not ask until the end before doing so. The sooner the better, if I can say so, because that will enable us to have our attention also attracted to your questions and help the panel then in this second part of our webinar to answer your questions. But let's begin now with the first panelist, Malte Beyer-Katzenberger. He studied law and political sciences and obtained a Dr. Jur degree from Trier University in Germany in 2007. Then he joined and worked at the Academy of European Law and joined the European Commission already in 2011. And he worked on different aspects, but most recently, he was very much involved in the drafting of the 2020 EU data strategy, the proposal I mentioned on Data Governance Act, and finally, the Data Act. So he knows everything about the Data Act, and I'm sure he will have the opportunity now to present the Data Act and especially the Commission's perspective or some aspect of it. And Malte, I'm thrilled to listen to you, and you have the floor.
Thank you, Pascal. Good evening to all. It's a great pleasure also for me to be here because I know some of you personally, and the exchanges over the years have been extremely inspiring and fruitful. I mean, I'll start maybe on a personal note, also that you can maybe situate the proposal in its philosophical, if you want, where political underpinnings, which is, I think, also important to understand. And then I guide you a bit through what is basically the genesis of the objectives, and then I'll focus on one part of the proposal. The team, now you take what you out of this what you want, but the team that designed basically the data strategy has the open data paradigm basically embedded. And why is that important? Because I think in the discussion that followed big data, if you take the 2015 OECD report on data-driven innovation, the notion of data as a non-rival resource, maybe data as an infrastructure that should not be subject to any exclusivity as a concept, is very strong. And it also was carried, if I want to say, from a discussion under the previous College of Commissioners, namely Commissioner Oettinger, that looked at questions of, or labeled a question around, framed it as a data ownership discussion, whereas now we are have transformed that discussion also as a result of many years of studies since 2016 onwards to actually look at access and use as the prime challenge of the economy. And the notion is that obviously data are copyable at very little cost, and that the data is also an experience good in economic terms. So the value is in the use of the data. Data as such has no value. The data comes from any of the users, and the very simplistic premise is the more use, the more value. Now, different data have different kind of usability or usefulness in different use cases, so that's also given. And there are also obviously the opposite kind of considerations, that there is investment costs that have to be recuperated. Now, the Data Act, and that's very much where also like two commissioners come in. Thierry Breton says we have to seize the importance of the data economy for the industrial data. But the Data Act by no means only covers industrial data, but there he thinks we can still have innovation around industrial use cases of data, and that we have to unleash. Margaret Vestager also very much studied already in the past role as competition commissioner the implications of data in the digital economy, and that also drove her to the conclusion that at least in certain forms we need to unlock data from any attempt, also in industrial attempt, to keep the data, to hoard data, to keep it in silos. Now, in the Data Act, we do a number of things. I will focus maybe on the most kind of intellectually and also legally complicated one, which is the governance around IoT data. Just saying, in addition to that, we have a little bit of contractual fairness, which is also interesting because it enters in business-to-business relations, in certain business-to-business relations, namely those for SMEs. We also have an opposite question: could the government benefit from private sector databases in responding to emergencies and other things? And then we also tackle cloud market and like consolidation of cloud markets and questions of switchability on cloud markets. But so we have a bundle of problems we're trying to solve. But I think the most intellectually interesting one is how we attribute or not rights on data. And building also on your work, but also on the earlier work on the German Datenethikkommission, where Christiane participated, obviously, we really came to the question when to give data rights, and can there be a horizontal logic of intervention, but that cuts across markets, sectors, or product categories. I mean, some of you know there's a lot of discussion around the smart car. You could possibly, and maybe the Commission will even complement the Data Act with specific legislation around the smart car, because you can then compartmentalize, if you want, the problem into different sub-markets, primary markets for the cars and aftermarkets and neighboring markets, and then competition lawyers can have a lot of fun to design sub-problems. We wondered whether it's actually possible and opportune to say, we'll put all IoT objects in one box and come, if you want, with a one-size-fits-all kind of proposition. And we think we can do that, and that's now maybe the intellectual question to you also, how you conceptualize actually data coming from a physical object, data coming out of a physical object as a result of the object being used. And whether you can actually go back to very fundamental legal principles and traditions would have to do with the question, what who should have rights of the produce of an object. Now, if I have an apple tree in the garden, obviously only one can get the apple and eat it. But with data, actually, we have a completely different paradigm. That's maybe my next argument, that we can say you can actually have the apple and eat it, or you can give the apple in multiple copies to different people. And what is the opportunity that arises out of that? Which already means that you can be the owner of the apple tree, and you can have a renter agreement on the orchard, on the apple yard if you want, and both can actually keep rights on the same apple. And whether that you can actually, well, first multiply the use cases, and then also settle the conflicts that may arise of different interests, that how the apple should be used and commercialized. Because obviously with costless copying also becomes a risk that things lose a value because you can't use the exclusivity anymore to actually then derive a monetary advantage. But that all then intersects with another point, which is the question, to what extent should we actually bet on value of raw data in the first place, and whether in the data economy, and that's also one of the premises of the Data Act, we should actually not try to focus so much on the value and the exclusivity around raw data, but rather on the capacity to use the data and on the services that can come out of this. Now, what is the arrangement for those who have never opened the Data Act? The Data Act basically says in those situations, well, let's say that it's a manufacturer and there's a user of the object, and maybe intermediate parties, seller, and there's component manufacturers upstream, and there's then third parties downstream. But we basically look at the manufacturer-user interrelation. And what we say that the manufacturer should basically continue to preserve the position it has today. So it should be able to actually agree with anyone who wants to buy objects from him or her to keep rights on using the data. This is a technical practice that happens in some markets, not in all markets. Not in all markets manufacturers keep these data rights, but they should have a capacity to do so. And what we say is, for transparency purposes and also to come later with maybe fairness challenges, you should actually contract about this situation. You should make this part of a contract, which already is one, I think, innovation. That's Article 4.6. But other than that, we say the market forces will determine whether the manufacturer can keep rights on the data. But now comes in a statutory right, which is not negotiable. It's cannot be derogated by contract for the user, which can be a consumer or a business who has a strong legal link to the object, which will be an ownership link or a renter-lessor link. Not the mere factual possession, and not the mere factual capacity to enter something, enter a plane or a train, or which we would also say, I'm using now a plane, but that's not it. So you have to have a strong legal link, and then you can derive a statutory right to go back to the manufacturer, says, hey, I know that you take certain data of this object, and I want to have the same rights, either for myself, because I can myself use the data. I'm a business. I want to do integrations. I have different objects. I'm a construction company. I buy a Caterpillar and a Liebherr and a Komatsu engine, and I need to optimize my firm, and I want to have the data points. Otherwise, I can't plan for the petrol refilling. Or you are actually have a right to actually give it to a third party because say, I can't do it myself. I want to have this. And this is basically then a statutory right that you have, and which should open up opportunities. I'll say 3 complication points. The first thing is how to make sure that the trade secrets of the manufacturer are preserved, but at the same time don't trump the data access right. Because if you know trade secrets law a little bit, you know that it's a pretty unilateral decision. If you can declare something unilaterally as a trade secret and keep it secret, and then it's a trade secret. But that would basically undermine the whole scope of the data access and portability right if you were, if it could be reduced at the will of the manufacturer. So that's complication point 1, where we still, and we make an assumption that you can't invoke trade secrets to not give to the right, but you have also an obligation on the user and third party to keep the thing secret. So at least vis-a-vis fourth and fifth parties doesn't lose a value as trade secret. That's maybe complication point 1. And then you have to, complication point 2, you have to respect the GDPR. And when you're processing data about an individual and you're not yourself the user, you should also respect the rights of this user. And the final point is maybe on what could also third parties do with it. There are certain limitations in terms of making competing products, but also doing things with the data that are not necessary to provide the service. And that's about profiling, but also further downstream monetization of the kind of highly individual data, which should really only be given in exchange for a service. And I'm happy to expand maybe on a little bit more on that, because I think my 10 minutes have to come to a close. So I hope I give you in a nutshell the construction. So it's around portability as a vehicle, which basically kicks it to the user to take then choices to whom it wants to give, but not attributing own rights of any third party. The third parties have to go via the user, because we consider the user to be a co-generator of the data in question. Thank you very much for the attention, and happy to expand later on any question you may have.
Thank you very much, Malte, for this very clear presentation, and that opens, of course, a lot of certainly a lot of questions, which is only one aspect, but really important aspect, it seems to me. We will continue immediately with our next panelist, and our next panelist is Christiana Vanderhoff. You know her, of course. She's professor of civil law at the University of Vienna, and she is the immediate past president of the European Law Institute. She has been president for the last 4 years. She is now scientific director of the European Law Institute. But if she's on the panel, it's not in this capacity, but because she was one of the co-reporter of the ELI Principles for Data Economy. She's also a member of the, as we have heard, of the German Austrian Bioethics Commission at the Austrian Federal Chancellery, and therefore she's also very much involved not only in conceptualizing these aspects, but also in looking further down how it might be implemented. And she has many other, of course, positions. So I don't want to take too much of her time by giving all her presidency and chairs and whatever, but of course her position at the Academy, Austrian Academy of Sciences is one of the, she's a member of the presidency now, and also a member of the American Law Institute. So she really is very much involved in all these issues, and especially of course, in the issue of data acts here. And so, Christiane, I'm sure you will present us in 10 minutes, in a nutshell, so to say, not only what the ELI have proposed, but also the consequences and the opening up of that for the Data Act. You have the floor and the word, dear Christiane.
Well, thank you so much, dear Pascal, for your kind words and for the invitation. In fact, it's a little bit difficult to present the principles and the Data Act and my reflections on both in 10 minutes, but I will just focus on very, very few points. The principles that were published last year, they fall into 3 main parts: a part on data contracts, a part on data rights, and a part on third-party aspects. And I will focus now on data rights, because as Malte has already explained, that part on data rights has been particularly influential when it comes to the Data Act. And the concept of data rights under the principles is a twofold concept. One of the most innovative parts, if I may say so, of the principles was the development of the concept of rights in co-generated data. So the idea that parties may engage in various activities, they may in various roles contribute to the generation of data, be it by being the subject of the information coded, be it by being the owner of the IoT device that generates data, be it by pursuing an activity that generates data. So people engage in activities and roles that contribute to the generation of data. And the idea is that by the mere fact that these parties have a share in the generation of data, they may have certain rights, in particular, but not exclusively, access rights. And those rights are afforded to the parties because they have contributed to the generation, and they arise from considerations of fairness and they are potentially already inherent in existing unfairness tests, and they follow, if you like, a private or property law logic. And concerning the question when and how such a right should be afforded, the principles identify 5 different factors. The share, I already mentioned that several times, but also the weight of grounds put forward for exercising your data right. The legitimate interests of other parties, and this is where trade secrets and also data protection interests of other parties may kick in, the relative power of parties involved, and public interest. But these are just one type of data rights. There's also another type of data rights, which we call data rights for the public interest. Now, these data rights are exercised by third parties who have typically not contribute to the generation of data. It may be a research organization, it may be another company that wants to develop an innovative product, it may be an independent repair service. They arise often from sectoral regulation, and they follow often a market failure, a competition law logic, or other public interest logic. And what the principles do is they identify 5 different principles that should govern horizontal access modality, the access modality. So the principles don't say when a public interest is sufficiently important to grant such a right, but they just say if the legislator believes it should grant an access right, then these are the access modalities. So access under FRAND conditions, fair, reasonable, and non-discriminatory, protection of third-party rights, the no harm principle, reciprocity, and the first one on the list should be a legitimate aim, and the proportionality test should be met. Now, this is in a nutshell what the principles say concerning rights in data. And we see, and Marta has already explained that, we see as a very similar concept now in the proposal for a Data Act. If you like, the Data Act merges both concepts, and this is maybe the characteristic solution we find in the Data Act, in a portability right. So you find like the ideas of both, and we can really trace all the elements also we find in the principles, also in the proposed Data Act, including the relative power of parties involved by giving privileges to SMEs and not permitting data sharing for the benefit of gatekeeper protagonists. Also, public interest, the share and the generation, we can find all that, but there are 2 conspicuous omissions. So the Data Act doesn't really look at the grounds put forward by the owner of an IoT device. So any kind of purpose, any kind of motive for the owner of an IoT device to share data is accepted. And on the other hand, it doesn't look at the purpose for which the third party will use the data. What is sufficient is that the user takes the decision to port the data. So it's a user-centric model, and basically, on the one hand, you don't need legitimate grounds because there is that idea behind the Data Act to liberate data for the European data economy. And on the other hand, you don't look at the purposes for which a third party will actually use the data, because the user's ownership right, if you like, and the user's autonomy is sufficient justification. So that is a conspicuous difference between the Data Act proposal and the principles. Another conspicuous difference is the role of contracts. So Malte already mentioned Article 4.6, and that is indeed a central characteristic of the Data Act proposal. So the Data Act says that there must be a contract. If a manufacturer of an IoT device wants to use user data, there must be a contract between the user and the data holder, the manufacturer, if you like. And there must then be a contract between the data holder and the data recipient, and possibly often also a contract between the user, the owner of the IoT device or long-term user of the IoT device, and the data recipient. And just to show this famous Article 4.6, which I think is really a central part of this notion, that we already had debates about that. That came a little bit as a surprise for us, because I'm wondering whether that means that we have now stricter protection for non-personal data than for personal data. I'm also not sure how the relationship with e-privacy law will work out. I'm not sure whether it concerns only the first data holder or any third party, but I'm sure that can be discussed and will be clarified during the legislative procedure. Now, last but not least, I will close by some reflections on open versus closed. What we see in EU legislation and elsewhere is two competing gold standards. So for a very long time, we've had the gold standard of the GDPR, which was privacy by default. And now, for some time, we've seen a competing gold standard of open by default. In the open public sector data debate, now also in this data sharing legislation, which we see, including the Data Act. And there is a certain tension between the two, because open stands for one hand of innovation and growth, a whole range of goals we hope to achieve, all sustainable development goals, if you like. And privacy stands for a lot of things we want to protect and preserve, including public interest, fundamental rights, national security, law enforcement, you name it, trade secrets. So everything we want to protect. And that is a tension. I think it will be one of the biggest challenges for data legislation in the future. And as Malte mentioned, the Data Ethics Commission, which I had the privilege to co-chair, it was just a temporary committee, so it no longer exists. But after a consultation with stakeholders and many expert hearings, the German Data Ethics Commission formulated this example. And it always makes me think twice about sharing data, because it demonstrates that even when initially you have the very best interests and the very best motives to share data, things may happen that you hadn't anticipated. You may combine the data you shared with new data, and then it may get into the hands of protagonists where you would not like to see the data. But I realize that my 10 minutes are over now. So just to wrap up, we are very, very happy to see that the proposal for Data Act has taken up many of the core concepts, in fact, of the principles. So in particular from part 3 and part 4, and part 2 may also become relevant for the model contractual terms that are going to be formulated. When you ask what are the differences, I believe there is a certain difference as to the approach towards open versus closed. I think the principles tend a little bit more towards protection by stressing the requirement of a legitimate ground, as well as focusing on rights vis-a-vis downstream recipients where those do bad things with the data. And the principles do not require contractual relationships between the parties. Of course, there's nothing in the principles that would say there shouldn't be a contractual relationship. It's good when we have a contractual relationship, but it doesn't have to be there. And I believe that Article 4.6 of the Data Act proposal raises a couple of issues that may need to be clarified. And with that, I thank you very much for your attention.
Thank you very much, Christiane, for this tour de force, touching upon both documents and then coming up with very interesting results to show the differences. And especially, I think also this difference between the contractual perspective and the right perspective that we have in the principles may indeed have some some interesting consequences, including on what we will discuss right now with the next panelist, with Mark Rothenberg. Mark Rothenberg is a founder of the so-called Center of AI and Digital Policy, and he's also an adjunct professor at Georgetown University Law Center. His expertise is very broad, includes data protection, internet policy, open government, AI policy, and so on and so forth. He has published extensively also in the field and served as expert on several panels for the OECD, on UNESCO, UN, and others, of course. And he will discuss today the issue of data protection challenges of the Data Act. And as we have heard with the two previous panelists, this might indeed be one of the important aspects or challenges indeed. So we are thrilled, Mark, to listen to what you have to say. You have the floor.
Thank you very much, Pascal, and it's very nice to be with all of you today. I particularly enjoyed Malta's overview and Christian's discussion. I will provide comments from the privacy perspective, but I'll begin by noting that this is a very timely discussion in the sense that the Data Act addresses directly one of the big challenges that governments face today in our era of AI, which is how to make data widely accessible and useful, particularly in the integration of machine learning models that seek to optimize industrial production based on a wide range of factors. Frankly, some of those factors may not even be initially known until the data is gathered. In farming, for example, we might, take data about soil conditions, not entirely sure what the outcomes will be, but then we find patterns that actually improve production based on these novel data sets. So it's a fascinating field, and at the same time, it also raises, as I think Malta suggested, some real tensions. I mean, on the industrial side, of course, you have data about your customers, literally who they are, their purchase practices, or your plans for future products that you don't necessarily want to make available to your competitors. So we have a sense through the lens of trade secrecy and intellectual property that there's certain types of information that firms understandably don't typically want to make widely accessible. And of course, the domain that I'm familiar with in privacy and the GDPR, we see a real tension between the ambitions of the Data Act and already existing obligations around data protection. And reading through the recent report of the European Data Protection Supervisor, the European Data Protection Board, the comments that they published earlier this month on the Data Act, one key point struck me, and that is essentially structural, and that is in the context of the Data Act. We contemplate a user who has access to a device. It could be an Internet of Things switch. It could be a tractor on a digital network. And that user has an interest in the data, as does the manufacturer. So as I understand the Data Act, we're trying to create circumstances where the user as well as the manufacturer are both able to make some use of the data that's generated by the device. But here's where the problem arises, and that is that the user is not necessarily the data subject, and the user is a party in possession of data with an interest in making use of the data that may or may not be aligned, with the interests of the data subject. And we actually experienced this in the internet policy world, almost 20 years ago when we litigated some of the first cases surrounding the use of persistent identifiers, also known as cookies. So you had website operators that were enabling advertising by using cookie tracking techniques. They were in effect the user of the website. The data was being generated about the person who visited the website. And the question becomes almost immediately, can the operator of the website make free use of the personal data that's being generated by someone else. And from a privacy perspective, we said, actually, no. You see, because even though you may have access to the data in the construction of the digital infrastructure, it actually does not answer the question as to whose interests may be implicated. And I think this is the starting point to understand the concerns of the EDPS and the EDPB regarding the Data Act. Now, they do acknowledge, as I understand in both the text and the recital of the Act, there's a full recognition of the importance of protecting the GDPR obligations. That is made explicit, and I assume there the goal is to provide the assurance. But even so, you know, the authors of this recent report note, for example, that the language in the Data Act is not the same as the language in the Data Governance Act, the DGA, which makes explicit that when these two doctrines collide, it's actually the GDPR that should be given priority. In the context of the Data Act, it appears to be more of an open question. And then there's another provision regarding exceptional circumstances, which also appears to create opportunities to make use of personal data that might otherwise be protected under the GDPR. There are, I think some good proposals in this report from the EDPS about how the Data Act, through some minor revision, could address the privacy concerns that arise. But rather than to go into the detail, I think the key point here to make is just to understand that the alignment of interest between the user and the data subject are not necessarily going to be the same. Nonetheless, returning, to this initial goal, which is how do we promote the widespread availability of data, I'm reminded also of an initiative underway at the OECD that was launched several years ago, actually by the former Prime Minister of Japan, Shinzo Abe, speaking at the World Economic Forum, called for data free flow with trust. And this phrase, data free flow with trust, has actually become quite influential as we think about the digital infrastructure, both to seek the benefits of data exchange and to enable transporter data flows, and to recognize simultaneously the importance of legal structures that allow the data to move in a way that provides assurance for privacy, for national security, and for intellectual property. It is still an influential paradigm, and one that I hope will be pursued in the context of the Data Act and elsewhere. I will caution that I've seen an approach to data free flow with trust, which is a reference to interoperable legal frameworks. And from my perspective, interoperability is very useful in the engineering and technology realm, but it's actually not a helpful concept in the legal realm, because what we're really looking for in the legal realm are harmonized legal frameworks that establish and maintain common standards, whereas interoperable as applied to digital free flows with trust strike me as an opportunity, perhaps in some circumstances, to avoid these obligations that would otherwise be upheld. Finally, one of the approaches that may help make some progress in this tension between promoting data flows and safeguarding privacy, of course, are around the techniques such as privacy enhancing techniques or privacy preserving technologies that essentially seek to anonymize or de-identify personal data, taking it outside of the realm of the GDPR, rendering it in a sense as statistical or aggregate information, which is of course the way governments have traditionally made census data available, for example, and census data by tradition has been useful for economic planning and made available to businesses. So we have even an analog-based concept of how we can maximize the use of data while safeguarding privacy. Of course, with regard to these techniques, we need to make sure that they are robust and provable and scalable. My own personal proposal for the use of privacy enhancing technologies to minimize the use of personal data is to assign the liability to the party that would otherwise be responsible if the de-identification technique failed to protect personal data, to say that you need to establish that your technique adequately de-identifies the data, and therefore you can avoid the GDPR obligations. So with that little liability rule, I do think that those privacy preserving techniques could help us make data more widely available. So it will be very interesting, of course, to see what happens next. I think the recommendations from the EDPS, EDPB report of this month are constructive, perhaps could be incorporated into the Data Act. But yes, certainly in our era of large data sets for machine learning, facilitating access to data should indeed promote some economic growth and opportunity. So I'll stop there.
Thank you very much, Mark, for this enlightening presentation, also on the conundrum between free flow and protection, and how through techniques things might potentially evolve, but also what is the danger of blocking everything and the free flow being blocked because of GDPR, for instance, concerns. And we will certainly come back on this tension between the interests of the users and of the data subject. I think we will continue now with this going more and more into practical consequences. And this thanks to Joanna Reninchuk. She's the Chief Product Officer of Homa Games, one of the largest mobile game publishers globally, with more than 500 million downloads. Previously, she worked as CEO of Game Analytics, and the most popular analytics tool for mobile games that it is, and which integrated more than 10,000 studios and reached 2 billion players monthly. So to say that she has seen or managed a number of data is really a little compared to these huge numbers. But this shows also the importance of this Data Act in our everyday life. And the implications that might be indeed very high. And that's why I'm thrilled now to give the floor to Joanna Reninchuk for some reflections on the Data Act in light of the ELI's work from this practitioner's perspective. You have the floor, Joanna. Thank you.
Thank you. So just to set the context a little, I think the Data Act is in principle kind of very orientated towards IoT industrial use cases. So mobile can seem like perhaps it's not the direct focus of the Data Act, but I wanted to talk a bit how the principles behind the Data Act apply to our industry. Because I think they can be far more far-reaching, and I think especially in data-driven industries, not just in deep tech. So in current industries like mobile and advertising, these principles are very relevant. So we have two major commercial companies that govern mobile today, and they are Apple and Google. They govern the mobile ecosystem through the stores and through their devices. So because Google basically is the main driver of the Android ecosystem, and Apple obviously is the Apple iOS ecosystem. The most notable change that happened in this ecosystem was when last year Apple decided to introduce privacy regulations to remove something called the IDFA, which Google followed. So essentially, this was an ID that was available on the phone. The concept of this ID is similar for iOS and Android, but it's an ID that it was used to serve ads to users. So companies could use it to identify a user who has seen their ads and then who had installed an application or who had bought a service. So this allowed to see the user when the user was served to the ad. So before the purchase and after the purchase, and connect deterministically that this was the same person. This allowed building highly complex user profiles of people and targeting ads at them. One of the main beneficiaries of this was Facebook, a company that was quite known for its individual profiling. In the advertising ecosystem, there are companies that use different technologies. Facebook is probably the most notable case of, or Meta now, of a company doing highly individualized profiling and targeting. Versus other companies who did not have the comparable data set and outlay of Facebook. So they did not also have, Facebook owns Instagram and WhatsApp and Messenger and Facebook. And also their ad services are incorporated in almost every mobile app you use that has ads. So they had a very deep view of what you were doing on your phone almost all the time. Now, the reason I am giving this entire context is to explain that when Apple rolled out this privacy regulation and essentially removed this ID or required an extra step of consent for users to give this ID and made it much more easier for users to refuse consent, what happened is, and also, by the way, this went in parallel with GDPR. So that's why, and Apple does not consider GDPR consent valid, which means that you have to ask for consent twice as a mobile developer, which further kind of changes the user experience. So when Apple did this was a case of a major commercial company creating a rule for everybody else, but not for themselves, even though this commercial company basically had, let's say, a vested interest in this environment. So as a result of this change, Facebook advertising, the efficiency of Facebook advertising went down, for instance, and the spend on Apple's own advertising services went up. Also, spend on Google went up because some spend moved from Facebook to Google. But that is a great example where Apple actually still has access to this ID. Apple still sees everything that everybody does. Only now they have the exclusivity of using this ID independently. A similar move is being considered now by Google, and it's actually broadly being applied by Google. So in principle, this is an example of where you have commercial companies creating an uneven ecosystem by holding certain data sets private for themselves, even though those data sets have a very broad impact on all other companies. When I say Facebook was affected, it can seem like, oh, but Facebook is a large company and so on. Yes, but all of Facebook's clients were affected. We were affected. A lot of mid-level companies, a lot of small enterprises, like small, medium-sized enterprises that relied on Facebook for their advertising, so for their e-commerce advertising, all of a sudden would have seen worse results. So the knock-on effect of this on the mobile industry, on everybody selling goods on mobile and having a service on mobile like an app, is this is literally like the biggest thing that has happened in mobile that affects mobile business models for years. And it's effectively like a case of uneven data in the ecosystem. Some people have more data, they have the option to refuse to share it with everybody else. And that's it. A follow-on thing that is considered in this industry, which is also because this was also interestingly just to start. A follow-on action is considered potentially restriction to the IP of the user. So by obfuscating the IP for different services, this would effectively make a user completely invisible to like completely undetectable. It would be impossible to tell who is who. Which again, technically for data privacy sounds like a good thing. It sounds like a good thing, like not being profiled. I think the challenge and what the Data Act, how the Data Act is related is that if everybody had the same rules applied to them, this would fundamentally be a good thing. But that is not actually the case. So you have commercial companies imposing these rules and commercial companies being affected by these rules, and an uneven ecosystem where you have basically two platforms that control everybody that goes underneath and that can kind of reserve more data for themselves than everybody else has. Fundamentally, it's unclear how public institutions would have access to this data. Would public institutions be able to profile people? Like if we had, the case of another pandemic, and we would really need to see that a certain person took a certain action, and that was, let's say, an action in like that would be needed by the health service for the public good and so on. Would it be possible to do that? It's impossible to know because again, these are commercial companies that are not regulated in this way as of yet. So I think although the principles of, like have been designed more to apply to kind of machine learning, IoT, data science, they actually apply and can be applied much more broadly to other ecosystems. And I think they should be applied more broadly to other ecosystems. I think this principle of evening out access to data so that smaller companies are not unduly affected by larger organizations effectively blocking access to data or preventing access to data, I think is a very good principle that I think is highly beneficial to companies that cannot enter especially to two types of companies that cannot enter these markets right now because the barrier to entry is so high. Companies that have no choice but to be locked into certain ecosystems that reduce their profitability or reduce their competitiveness because they must use those channels to access their users and access their clients. And three, actually other large technology companies who could provide competitive services but are blocked from doing so by access to this kind of fundamental data set. So it affects multiple tiers and also fundamentally the end users who get services that are affected by this discrepancy. So this is a use case, like it's an example of these principles being very valid and applying across sector and applying in sectors where it wouldn't be so immediately obvious. And yeah, I think I look forward to seeing more applications of the principles and more guidance on how to apply these principles yeah, from institutions.
Thank you very much, Joanna. And I must say it's interesting to see how what you've just said goes back to the differences underlined by Christiane between the Data Act and the principles linked to this contractual arrangement and this statutory right to get free flow of data, for instance. I'm sure we will come back during the discussion to this. And I take this opportunity to remind all the participants to ask questions, and to do so, of course, they can use their Q&A section already now if they have questions coming up in their mind. But before turning to the questions, we have a last panelist that joined us right now, a couple of minutes ago, Paul Keller. Paul Keller is a research fellow at the Institute for Information Law of the University of Amsterdam, and he sits on advisory boards of the Glusco Samuelson Information Law and Policy Lab and on the Europeana Foundation, but he is above all, if I may say so, a media activist and an open policy advocate and a systems architect to improve access to knowledge and culture. So we spoke about this free flow of information, of data and trust then. And so probably this is exactly, if I understand correctly, the approach he tends to promote. He has a deep understanding of the digital transformations, political, social, and legal implications. And I wanted to say now he will show us that this is true by giving some reflections on the Data Act in light of these specific perspective. Paul, thank you for being here, and you have the floor.
Thank you very much for the kind introduction. That was quite extensive, but misses the function in which I'm speaking here, which is I'm also director of a Amsterdam and Warsaw-based think tank called Open Future, and as Open Future, we're following EU policy files with a specific eye on, as you explained, advancing issues related to openness, open access to culture and knowledge. Right, like we're trying to work with the EU institutions on improving policy files in this direction. And I apologize for not having been able to follow the entire seminar. My colleague has been following this and has kept me a little bit updated. It's quite a shift, I think, from the practitioner perspective who deals with like billions of data sets in her professional life, towards like a more conceptual approach where we think like there's room for improvement in the Data Act. But there was in one of your remarks, Joanna, there was a nice bridge to my talk where you wondered about like how do public institutions in cases of emergencies or in cases of public interest users can gain access to data held by private enterprises. What are the rules for that? And as those of you who've been looking closely into the Data Act will know, is that the Data Act, or the proposal for the Data Act, includes a chapter 5, which deals with this scenario, right? And I want to touch a little bit. We actually published a policy brief on this today, which I will share in the chat in a little bit. But we've generally been quite favorable of the proposal of the Commission for the Data Act. The one thing where we really think there is substantial room for improvement is this chapter 5 that deals with what's called business to government data sharing. And if you look at, or if you're familiar with these discussions, you know this idea of business to government data sharing, or data for public good, or reverse PSI is something that is a discussion that's been running for almost a decade now. The Commission had a high-level expert group on this thing. This is something that has been relatively extensively discussed also in the preparatory documents for the Data Act, the inception, the impact assessment. There's been studies by external consultancies who've looked in these issues, and all of these preparatory documents have, at least in our reading, advocated for more forceful interventions in this field, right? Like, and it seems that the Commission has, in making its final choice for the Act, chosen a relatively safe option with a relatively limited intervention in this space, which limits the business to government data sharing to sort of ad hoc, non-structural scenarios, right? Like, this focuses pretty much on public emergencies and situations of exceptional need. And I will share my screen now, and oops, the host has disabled participant screen sharing. So can we try that once more? I think it should work right now. And I should be able to share my screen now and show you my the slide deck. I hope I get this going. Can you see this?
Yes, perfectly. Thank you.
So, and this title slide is just for illustration. So what we're proposing is a more ambitious approach to public interest data sharing from business to government, right? And as I explained previously, we think one of the drawbacks is really that this is an ad hoc scenario, which is not very strong, that the Commission has developed. The Commission, the proposal, for those of you who are familiar, makes a difference between two different justifications for data sharing. One is to respond to public emergencies, and another set is a couple of other connections with public emergencies and what's called situations of exceptional need. And we think that especially this, in this flowchart, it's on the right side, like this scenario where it is about situations of exceptional need, which comes down to public sector bodies needing data in order to exercise their publicly mandated tasks. This could be improved quite significantly. So what we're doing here is that we propose to add a stronger public interest data sharing mechanism that is in line with the stronger policy option from the impact assessment. And that would work through the introduction of a public data commons body that essentially stewards the public data, or the data that is shared from private entities to government entities. And so there's basically these two flows, and I have a sort of comparison table. In cases of public emergencies, and this is in line very much with what the Commission has developed in the proposal, so where the purpose is to respond and prevent and aid in the recovery from public emergency, the data would be shared, would be requested by public sector bodies. The party from which it's requested would evaluate the data sharing request, and if it agrees, the data would be shared and made available to the requesting public sector data body, which would essentially delete the data after its use, so after the purpose that for which it's been requested has been achieved, or at least after that data is not necessary for that purpose anymore. And the cost here is free of charge. The other scenario, which we think is potentially more important if we really want to unlock the potential for of data for public good, for the public use case. So where privately held data can contribute to the realization of higher level public objectives, higher level societal objectives, would be what we call public interest data sharing. And this is related to public interest users, so securing something like the health system, the functioning of the health and education system, combating climate change, ensuring strong and just public institutions. But this is obviously something which needs to be refined in the process. And here the review, if a data sharing request by a public entity has been made, should not be made by the requested party, so the data holder, but instead by the national competent authorities, which are introduced by the Data Act. And if the national competent authorities agree that such a request is justified, so in line with the public interest justification, it is proportionate, it is otherwise legal, then the data should not be shared with the requesting entity, but with a public data commons body, which aggregates all type of data and keeps it available for requests from other public sector entities, from researchers, from NGOs, but also makes it available to the requesting entity. And in this scenario, similar to what the Commission again proposes in its scenario, the cost for data sharing would be borne by the requesting party, and this is like the incurred marginal cost plus a reasonable margin. So we really think here is quite a lot of potential for improving this and for delivering on this data for public good narrative that the Commission has developed in its data strategy, and really think further than just enabling empowering individuals and other corporations through this access to data, which is a very strong and very welcome introduction of the Data Act, but also figuring out a mechanism where we can build a corpus of publicly available data that is available through this public data commons body. As I mentioned, we've published a policy brief just on this issue just today. You can download that from the website. I'll post the URL of the website also into the chat once I'm done here. And I would thank you for your attention and the possibility to present here, and I'm open to questions. And back to you, please.
Thank you very much, Paul, for this very stimulating proposal as well. And I'm sure that will trigger some reaction both from Malte, but maybe also from Christian and others to have a kind of data commons is, of course, an idea which is certainly interesting. So we will come back to this, and I see that we have already one question, so I will begin with this question, and then if we have further questions, we will deal with the further questions, but you may also react on what others have said during the Q&A section when I will give you the floor. So the first question that we got here is a quite general question. I may read it out. How do you foresee that the trade secrets protection in the Data Act could be enforced? How would manufacturers even find out if, for example, a third party has created a competing product through some form of reverse engineering of data they have gained access to, let alone prove it? Smart contracts, of course, provide very little actual protection and are fairly easy to bypass. So not only we have this tension between data protection, privacy, trade secrets against free flow, but then we have the whole difficulties of finding out when something occurred, when a breach occurred. And maybe I will first give the floor to Malte Breuer-Katzenberger to see whether he wants to address that, because I can imagine that in the process of preparing the Data Act, you had to ask yourself these type of questions as well.
No, thank you, Pascal. And I should not now react to other presentations, right? Okay. No, I mean,
now.
Yeah, this is a practical challenge. I mean, that's acknowledged. It was a practical challenge before the Data Act, and it will be after. It's also the whole construction of trade secrets protection builds on the fact that you find out and that you can actually prove. And if you know the Trade Secrets Directive, there's a number of prohibited behaviors in Article 4. But how do I prove that someone was actually in bad faith acquiring the data? I think that's the challenge which existed so far. Now we're probably increasing, because of the availability of data, the number of risk points. Maybe, I don't know, it's a speculation, but in theory we do. So it remains a challenge. But if you know your market a little bit and your competitors a little bit, you will observe the competitors. And if you have a suspicion that something functions exactly the same way as your thing functions, you will go after them. But yes, there is a trade-off in terms of stimulating this innovation, leading potentially to many useful business models, and the risks for the incumbent manufacturers. That's why we try to be as reduced and encourage them to say, give them as raw as possible these data. Don't give data that have been already subject to a refinement process, which in itself could be trade secrets protected. That already would cover a substantive number of use cases. And then there's the residual use cases, which we're also still trying to find out on the exact kind of nature. What are these? What are examples? And it's not easy for industry actually to dig them out, not because they don't exist, but because it's hard also to have the internal conversations. Sorry, long answer to a actually pretty poignant question, but it's a complicated one.
Thank you very much. Maybe I can continue with some points that were brought in during the discussion, and maybe Christiana, you might want to answer this question about the data user on the one side and the data subject that was raised by Mark as a very concrete example, and whether in the ELI perspective, I mean, ELI principles, you address that in a way or in another in chapter 3, and you may elaborate on that if you want to.
Yes, thank you so much, Pascal. Indeed, this is one of the trickiest questions we have to deal with. To remind us that the ELI principles do not deal with privacy as such. So that was a decision we made at a very early point, that the principles should not focus on data protection or privacy law as such, meaning that the principles would not take a position on, what are legitimate grounds for data processing and the like, or under what conditions do you have to give consent and can withdraw consent. So that is nothing the principles would be dealing with. What the principles do is they give some guidance as to how to deal with third-party protection in a data value chain, or how to build third-party protection into data sharing arrangements. So this is the kind of guidance the principles give. And given that they are principles and not rules, they take this rather flexible factor approach, which would allow for consideration of data privacy issues at various levels. So it would already come in at the level of deciding whether to grant a data right, such as a data access right, because the legitimate interests of other parties are one of the main factors to be weighed. It would then come in at another level when deciding about what kind of protective measures should you impose if the data right is exercised. So should you impose anonymization, blurring of data, that the algorithm comes to the data rather than the data to the algorithm, a data trust scheme or a data intermediary scheme, other technical safeguards or organizational safeguards. That's all in the principles and to be applied in a rather case-by-case manner, which is something principles can do, but I realize a law, a hard and fast rules in a law cannot so easily do as principles can. And then we have that part 4 on third-party protection, which gives guidance, for example, what to do when you share data. And there are requirements such as when you share data, even if you are allowed to share data, you have to kind of impose the same restrictions you were laboring under on the recipient. And you have to apply organizational and technical means kind of to make sure this is really complied with. So the principles deal with this at several layers, but I think it's one of the most intricate problems we have to face.
Thank you very much. Maybe we can continue. Malte, I think many points that were raised by the others were addressed also to some aspects of the Data Act. Data Act. And so maybe you could begin by answering or reacting to some of the aspects, including maybe also the unfair competition perspective that was raised by Joanna to some extent, at least.
No, that was an interesting, actually, pointer to say that we may need to look at different ways to enforce competition. And our suggestion is that with the portability, right, you have a cross-cutting structural remedy, whatever it will be good for. I mean, you still depend on the user to take actions, and you will be dependent on that person to carry it through if something goes not as planned under the Data Act, and there's a lot of implementation, as you see in Article 4 or 5 situations. But one thing I wanted to maybe quickly clarify with Mark and also the colleagues at the Data Protection Supervisor and Board, we had the chance to also talk through the draft opinion. There is a deliberate deviation from using the language in case of conflict, the GDPR should prevail, because actually Article 4 and 5 of the Data Act want to prime Article 20 GDPR and maybe Article 15 if you want it. So the access right and the portability of the GDPR, because of the enhancement. So we couldn't use the same, for that very simple reason, we couldn't use the same, we couldn't use this this notion. I'm very much intrigued also by the allusion to the census data, which is indeed what the Data Governance Act already tried to stimulate for public sector data that would be complicated to extract, and where I see also Paul Keller's comments on the data commons going. And maybe in that perspective also for Paul, it's interesting to look at how the European health data space legislation tries to solve the problem, which very much rests on what they call a data permit authority as a middleman between data holding private parties and public parties and data using private parties and public parties. Actually, the health data space sees all the four constellations, B2B, B2G, G2B, and G2G even. And they all are intermediated by this access body. And that's actually where the algorithm can come to the data, as many of you said. I think we're still, I'm personally extremely optimistic on the potential of this, because also statistical offices have tested this now for years. But I was really grateful that it was brought up, because we probably need more of those to intermediate these conflict situations. And that's also in the context of the trade secret situation, could be a remedy if parties accept and these intermediates come into existence that basically say, well, okay, I can understand you have a certain use case. You don't want to tell the potentially competing manufacturer what your use case is, because he shouldn't know and shouldn't take this business inside. But the manufacturer also wants to be assured that you are not abusing his data. So maybe indeed fiduciary instances in the middle are very much needed. I mean, this is a very nascent conversation with the Data Act, the Data Governance Act. We gave them a little kind of framework, but it's still a very nascent thing. So that's why we haven't really used them, if you want, as a legal obligation in these business-to-business situations. The health data people have examples in health, because that's FinData, that's the Health Data Hub, and maybe even Statistics Austria now has also a kind of these centers, and Germany will have a Forschungsdatenzentrum. So we will see them more often, but I think there's not enough faith, I think, to make it really compulsory for any type of situation and data. So that's maybe to be also brief and fair with the others to stop it here, but very interesting perspectives. Thank you very much.
Thank you very much. I think that even in the principles, ELI principles, you have some default rules or to have contracts for these fiduciary intermediary people. That might be a way also to set up something, but maybe Christiana can come back on that if she wants later. I wanted to have a reaction by Joanna on what she heard, and maybe she wants to add something, especially because in the Q&R section, we have someone asking whether there might be remedies for private enforcement and private remedies. And of course, in the private sector, you may think of that, or you may think that's worthless because it's too difficult. I don't know. So maybe you want to react on that, or on other points that were mentioned.
I would say an interesting point where we had an interesting use case is this kind of contracts and kind of competing products. There have been recently not recently, but like in the past couple of years, cases to try to determine when a product was copied or was using broadly like the same technology or principles and so on. These just went on to be commercial trials, and they had mixed results. But I would say once the first one happened, then there were like a series because that was covered in the press in our industry and mobile, and then that kind of had a series of knock-on effects. But then more people submitting these, and then kind of forming a precedent, which I think, although the trials weren't necessarily super successful per se, so I think the results were somewhat mixed. But I think the fear of litigation itself created a situation where the people that were creating these situations were less likely to engage in that behavior. So I think there are some self-correcting mechanisms in these cases, in some cases in industry or in specific niches. I would say, however, I'm at an industry event and we were speaking with regards to anti-competitive practices and class action lawsuits. And if like a group of companies would really get together in the way individuals do to do something like a class action lawsuit, I'm not sure if the correct term, especially as it refers to European law, is class action lawsuit, which I think is more like an American term, but that's kind of the term that we in the private sector were using for like a group of us suing like a large organization. I think that still feels unlikely. I'm not sure why. I think there's just no precedent that we can consider right now that again would lead a group of companies to kind of band together and truly do this. Also, these lawsuits tend to be extremely expensive, and the added implications of doing it in a group, like with individual lawsuits, like you're aware that your own responsibility is limited, and you trust like a legal team. With a company, you I think would want a lot more control, which would actually kind of complicate the process and so on. So the point is, I think there are barriers that have not been crossed in the private sector in terms of commercially enforcing regulations where like a regulator themselves or an authority themselves don't kind of jump in to enforce the regulation, or there aren't exactly strict measures for how to enforce the regulation, so you just want to rely on contract law. But I would say again, there have been cases where it's happened. They've been 1-to-1 cases, not many-to-1 cases. So I think this many-to-1 cases, if this does happen, for sure we'll be keeping like a very close eye on it. And at some point, it maybe would be interesting to do one of these webinars on some, like from the European Law Institute, on some of the more interesting legal precedents that have been established through trials, and like some of the more interesting cases, like judiciary cases like that companies could learn from in terms of protecting their interests. Because I think unless you hear about it from the press right now, you would not hear otherwise. And maybe in other countries there would be precedents that are interesting, but we would not necessarily know to apply them. I hope that's helpful.
Thank you very much. Thank you also for this idea. And of course, the more contractual perspective of the Data Act may trigger more private enforcement mechanism, whereas, as we have heard from Christiane, the right-oriented principles may have triggered or may trigger more regulatory interventions. And maybe that's also one tension. I'm not sure, but I try to balance that. So I was, before going back to Christiane, I had a question to Mark, because of course, in your practice, you also had private enforcement claims and so on, and maybe you want to react to that or to something different. You have the floor, Mark. You're on mute.
With regard to access rights, well, this comes up oftentimes, with government data sets where there are access claims to promote the use of information, and then, of course, the competing privacy, intellectual property, trade secrets, and even national security claims. So indeed, we did litigate a lot of those cases. But the other relevant background I had, and this goes back many years, in the 1980s, the United States was trying to make government data sets more widely available in electronic formats. So efforts were made to publish agency data, not private information, by the way, not personally identifiable information, in data sets that could be routinely used by those in the private sector. Where those lines can be easily drawn because they don't implicate the categories that Malta has already mentioned, I think it's very good to promote access. And finally, to Johanna's question about the competitive data that Apple and Google keep that advertisers may like access to, we have in the telco sector created affirmative obligations on incumbent companies to make it easier for competitors to get access to data to promote competition. So that's another strategy. I don't think the Data Act anticipates that approach, but it is the case. I mean, on the one hand, we all think it would be great to have access to as much data as possible, because as Malta said at the outset, it is a non-rivalrous good. But once you've attached some value to that data in a commercial context or another context, you may then be reluctant to give it up. And that's the tension.
And so would you say that this would lead to this proposal made by Paul saying, okay, we have public interest data, and therefore to have a commons accessible to everyone almost, right? Of course, regulated by administrative bodies might go into that direction, Mark?
Well, again, the spirit of the data commons is also something that's, gathered support on this side of the Atlantic, but we all, how to say this, we all want access to other people's data. And at some point, we begin to ask the question, well, what if it's, our proprietary information and our personal data? I do think that one of the key solutions here has to do with the anonymizing techniques that render information not personally identifiable, reducing risks also on the commercial side. And in that sense, also encouraging innovation, because if those techniques work, then we get the benefits of data. We don't have the same risks in the privacy world, and it is a, if you will, non-zero sum outcome.
I see. Thank you very much for that. This leads us, in fact, to another question we had in the Q&A chat box, where the question was asked whether that would also cover the not raw data, but data that were already elaborated and would get to of course, trigger more interest, even more interest by third parties. And so I wanted to throw this to Paul Keller and say that when you have these public interest, commons, what type of data are you really envisaging here? Only raw data or more elaborated data? And then what are the limits, of course, to this prior proprietary perspective on these data?
So I think we envisage mainly raw data, right? Like, this is not to expropriate entities that have business models based on data, where they enrich data, and where this is something that we're seeing scenarios, for example, in the field of environmental data, where it could be emissions data, or indeed anonymized aggregate data on population movements in the case of emergencies, etc. These type of data that we're seeing, like, I think there is safeguards built in there in the model we're proposing, where there is an evaluation outside of the emergency situation. There is an emergency. There is an evaluation if this is a request that is proportionate, that contains sufficient safeguards, and then there's a second layer. This public data commons is not an open access data commons, so this is not data that is then automatically made available to the public, but requests to that from researchers or from other public sector bodies need to be duly substantiated as well, and would also be evaluated by this public data commons, which acts as a steward of this data, right? Like this data gets collected for public interest use, not as a, if you will, free for all open access commons, where this data is basically another mechanism of redistributing data from commercial entities to other commercial entities that can use it for each and every purpose. So there are a number of structural safeguards built in here that clearly privilege users that come from, that are from public institutions, that come from the field of research, that come from civil society, that try to use this data in order to benefit society as a whole.
Thank you very much for this answer. I see that the clock is ticking very quickly, so maybe I would give the floor to Christiane first, then maybe Malte for so to say the last word. Not that you are accused, of course, but given that we are discussing the Data Act, you may have the last word. And Christiane, I was just wondering, we spoke a lot about, and you mentioned that also, that the difference between contractual and right-oriented perspective, and now also this right-oriented perspective for private entities and for public goods. And maybe you want to reflect on that, or you may say something else, but I thought that might be interesting from the ELI principles perspective.
Yes, absolutely. Thank you so much, Pascal. As we envisaged it, the rights in code-generated data, they kind of follow a private law logic. So even though I said you don't necessarily need to have a contract, it's still a private law logic. It's something a little bit like ownership. We don't call it data ownership, and it's not like ownership in the traditional sense, but it's something like ownership. It follows an ownership logic. And whereas the data rights for the public interest, they don't follow a private law logic. They usually are based on regulation, mostly sectoral regulation, but could also be horizontal regulation. So that was the difference drawn by the principles. And again, that notion of a contract, I think the contract can facilitate lots of things. And the question was raised in the chat about private enforcement. Well, if you have a contract, then probably, hopefully you can enforce it, but it can also raise a couple of issues. And I hope that we're going to see answers to some of the questions during the legislative process. Thank you so much.
Thank you very much for that. Malte, so you had the final word. In the Q&R, we had also a question about balance between users' right to access and data holders' ability to implement technical protection under Article 11. Maybe that leads also to some conclusion on your side.
It's a privilege to be the last speaker, and thank you very much for that honor. But I think the conversation will continue, as Christiana said, with also the amendments brought by the co-legislators, and we will certainly need that to improve the text in one or the other direction, also to take the full political appreciation where to draw indeed the line between how much do you have to give away, and if you think it's your investment primarily as a manufacturer, and how much you have also to, well, acknowledge of the fact that the user has contributed. But indeed, in order to balance out the kind of this conundrum, we say the data should be given as raw as possible and as useful as necessary, or the other way around if you want, so that we have it at an early stage to protect all the investments into further refinement. We haven't even spoken about the database right under Article 7, which is also an investment protection of the old world, so to say, of the 1990s. But it's there, and we have a specific solution to that, so that we really say what's the exact level. And then also the question to what extent you can actually use technical protection methods in conformity with the legislator's choice. You shouldn't try to undermine it and hollow it out and to play little tricks, as it will happen. It's very normal, and it will take a bit of an enforcement authority to look after this. But obviously, and that's maybe it's not, I don't know why it's not so obvious in the text, but for our lawyers, it's very obvious that a law, a European regulation conferring rights on individuals and entities can be invoked in court. I mean, this is a private enforcement is by design part of it, without that you even have to mention it. So the private enforcement is there. We have collective representative actions for consumers. That's one of the amendments in the last part of the instrument. We could certainly think about collective action also by legal entities. That would be, I think, something rather novel in the European field, but here I'm in your capable hands to tell me that it's not so novel. And we can certainly, I'm happy to discuss also that, but otherwise it's private enforcement, individual private enforcement, and the competent authorities to look after maybe structurally relevant cases. But yes, I think it's an interesting, an interesting sphere, an interesting approach, and the sector-specific access rights, which are called the public interest access rights, a terminology that I sometimes struggle to place because we call B2G also in the public interest, but the sector-specific competition-driven access rights may come on top. For automotive, they may come on top because we're already starting this. For health data, we have a specific regime, but that's also a different type of data. And then we'll see whether we need additional rights in specific individual sectors where there is a structural problem that competition law as it stands today can't manage. So thanks to the organizer. Thank you, Pascal, for the excellent moderation. Thank you to all the contributions, and we're really happy to be part of this and solicit us for individual conversations as well, as we will.
Thank you very much for these closing remarks. And indeed, as you mentioned, there will be further discussions, and probably the ELI will need to have yet another couple of webinars on these issues, because I think tonight's discussion showed how many very difficult issues should be addressed and could be addressed also through these panels. It's probably frustrating for all the panelists to have been able just to mention a couple of their ideas, and I ask for their, I apologize for not giving them more time, but time was limited, and that's the purpose of these short webinars. But thank you very much to all of you, because it has been very stimulating, and I'm sure all the people that listened to this debate and contributed were really confirmed that they need, first of all, to read this Data Act if they haven't done so yet, and that this opens a lot of very interesting perspectives. So thank you to all of you. I look forward for further discussions and following the evolution within the EU Parliament and Council, and have a wonderful evening. Thank you for being with us all. It has been terrific. Thanks.
Hi, everyone.
Thank you. Bye-bye.